Hello everyone, I'm Giuliana and I'll be explaining some aspects of contract law, concealment and non-disclosure. In the Restatement of Law of the United States, sections 160 and 161 deal with these subjects. They were established for the court to regulate improper bargain practices. First, concealment. Section 160 explains that it occurs when one party keeps information on purpose. By doing this, the wrongdoers state that the concealed fact doesn't exist. In other words, it is an intentional failure to disclose material facts. For example, the owners want to sell their house, but the walls of the house have many stains due to moisture problems. The owners put a mirror to cover up the damp stains to make the buyer from learning this. The law will take that action as if the owners stated that the house never had this problem, which is a misrepresentation. Okay, now let's move on to non-disclosure. Non-disclosure is equivalent to keep silent in certain situations. But we need to consider that non-disclosure is based on the doctrine caveat emptor, which means buyer beware. This aspect faces a challenge for contract law, because each party of the bargaining practice is looking for his own benefit. It is not illegal as long as the selling party is not lying. But some situations require honesty and fairness, so one party is asked to speak up. Otherwise, his or her silence will be equivalent to an assertion that the fact doesn't exist. Section 161 explains those situations. Subsection A, when a party has made a prior declaration, and the failure to speak up will render that declaration to be misrepresented. For example, the case Hill v. Jones. The Hills wanted to buy the Joneses' house. They inspected the house many times and asked about some ripples. The Jones told them that the ripples were produced by water damage. The house passes the termite inspection, but the Jones never told the Hills that many years ago the house suffered from termites. The Hills bought the house, and later the floor collapsed due to damage caused by the termites. Here, this section imposes an obligation to the selling party to disclose the facts and correct the buyer's misperception. Subsection C. Here, one party knows that the other party has a mistaken perception of the facts of a contract, so he or she has the obligation to correct the misunderstanding. Subsection D. As the parties have a relationship of trust and confidence, one party is entitled to know the facts, and also that party has special obligations to the other party. For example, when one party acts as guardian on behalf of the other party. In this situation, if the party with hidden obligations doesn't disclose a fact that is relevant to the other party, the law considers that the fact doesn't exist. Subsection B. Here, the party asked to disclose a fact may show no responsibility for the other party's confusion, but due to considerations of fair dealing and honesty, the party must disclose the facts to correct the mistake. On the other hand, there are some considerations for fair dealing and good faith actions. In these situations, the party doesn't have to disclose facts. First, when one party had to bear the cost to acquire some contested information. That information is considered as his property and the party is not required to share it. And second, when the facts of the transaction are easily available for the other party. Well, to sum up, concealment is the act to intentionally keep information from the other party, and non-disclosure is the action of remaining silent. Despite that, there are some situations where the law requires a party to speak up the facts. And that brings us to the end of my presentation. This is no easy subject, but I hope my presentation helped you to understand this topic of contract law. Thank you.